The Great State of California. Department of Industrial Relations. Labor Commissioner's Office. Address located at Number 2 MacArthur Place, Suite 800. Santa Ana, California 92707. laborcom.wca.ana@dirca.gov. Fax 71466266048. This matter regarding an active wage claim case number WCCM 801208. The contents hereinafter addressed to the attention of the Honorable Deputy Michelle Ellington. All matters relevant to this case were brought in by plaintiff. Plaintiff. Improper person. Full legal name. Quang Viet Tran. 9722 Imperial Avenue. Garden Grove, California 94844. Telephone 71488900048. Cutran98@outlook.com.
Versus B. Bui Nguyen, Elizabeth Nguyen.
Hanoi Plaza LLC. Saigon Center LLC. Does I through X, inclusive, and ROE. Business entities I through X, inclusive. All are defendants. Plaintiff. Complaint for equitable damages. Punitive damages. Compensation of unpaid wage and request for reimbursement on stolen personal properties. This is an add-on amendment to the preliminary pleading, its purpose to expressly focus on Part 49 and its subparts in the Section 5 factual statements. Its narrative's timelines require a better clarity by emphasizing the sequence of events leading to defendant's outrageous conduct. An intentional act with mindful calculative targeted at plaintiff inflicted harms to plaintiff. This paper expressed the severity of the damages affected plaintiff physically, emotionally, mentally, and financially. Plus, aligned the communicated emails with the events as exhibits. Plaintiff hereby self-acknowledgement of the legal accountability for the allegations and made by plaintiff throughout this legal document against defendants. Plaintiff remains under a bona fide oath which stated as legally sworn in the preliminary pleadings, respectively, the events and communications occurred factually as plaintiff described in the followings. From both defendants, the mother defendant B as well as the daughter defendant Elizabeth, their similarity often reviewed through their attitudes as self-righteous self-entitlement to above everyone else, with their grand title as the landlords, full conscious, disregarded all matters concerned to the well-being of plaintiff, selfishly demanded working results beneficial concerned solely to defendants expected deliver by plaintiff and when that failed. That was time when defendants shown their truth evilness demonstrated by their conducts to punish plaintiff. Its matter be as narratively presented as factual in this amendment paper. Subparts 49, The Outrageous Act. Approximately mid-morning on June 17, 2020, a person whose name is Jose Sanchez and is the foreman of a work crew with 4 other workers, hereinafter Foreman Sanchez, came to plaintiff's residence to visit. Foreman Sanchez admitted that his visit is sent by defendant to check up on plaintiff also to see if he can get the keys that plaintiff had in possession. A sworn affidavit from Foreman Sanchez will be added. Plaintiff had no reason to keep the keys, thus handed the keys to Foreman Sanchez. Plaintiff instructed Foreman Sanchez to make sure that defendants or defendant Elizabeth would get them, and plaintiff also asked him to let defendant Elizabeth know where the rest of the keys were, in Unit 205. Foreman Sanchez offered plaintiff help to move plaintiff's belongings out the workshops. At time, limited by the work injury the other day, and plaintiff with the injured foot at its toe started to show signs of infection. Thus, in this condition plaintiff could hardly walk and it will be no use to move things out and to other storage. Plaintiff had expressed to Foreman Sanchez that plaintiff still's affected by the injury from work that smashed the right toe of plaintiff and at time plaintiff was experienced mild fever and needed bed rest, needed to be excused. Plaintiff felt severe pains whenever the heart pumped as the blood pressurized flow passed through plaintiff's injured right toe. Approximately 10 p.m. plus on the same night, June 17, 2020, a person whose name is Sang Nguyen came to visit, hereinafter person Sang. He is a former part-time assistant to plaintiff as a part-time trainee and aide to help plaintiff couple hours each day. Person Sang informed to plaintiff that defendant Elizabeth asked him to help defendants with some works at the Saigon Center, a commercial center owned by defendants. A sworn affidavit from person Sang will be added. Plaintiff explained to person Sang that plaintiff no longer had keys for him to open the workshops and get all other keys accessible to the whole place. Plus, at time plaintiff could hardly walk and not feel comfortable to go outside without a pair of shoes on. The injured toe limited plaintiff from ability to put on his shoes. Person Sang said that this task will not need keys and the matter was homeless related. Side note number 1, the defendants just fired person Sang last week and now have him risks infectious coronavirus in the middle of the night and plaintiff guessed that person Sang will not even getting pay for the time. This plaintiff was rights later asked person Sang, he confirmed. Plaintiff realized a level of dangerous plus now under COVID-19 lockdown curfew in this early stage of everyone is their own survival mentality, which can be a cause for these unfortunate folks to react unfriendly toward anyone who denied them a safe spot to rest overnight, beside where else for them to access to clean water but at these commercial public buildings during the pandemic. Evicting the homelessness away from the property, this never was an easy assignment. It demands flexibilities in people skills and more to handle it. Since this typical task, defendants often called plaintiff at nights and requested plaintiff to go to their plaza and the center chased out the homeless for defendants during the past 3 years without a dime to earn. Plaintiff could not allow person Sang to do this by himself, especially during coronavirus pandemic that be higher the risks for him. Side note number 2, plaintiff probably could recall 1,000 of nights that defendants taken their advantages put plaintiff to work in high risks and potentially dangerous without pay at the least for the cost of gas. Defendants were even shy of not counted for reimbursement. Most time plaintiff personal bank account ran down negative by done the works for defendant cost out of pocket and whenever asked for reimbursement defendants counted and acted those funds were a gift to plaintiff. While everything is worked for the defendants, even the car plaintiff, driven with the workloads ordered by defendants, plaintiff never had a time to use that loaned vehicle to go anywhere purposely for plaintiff as personal usage. But when the defendants listed out the good things that defendants had done for plaintiff, defendants counted all the benefits that defendants provided to plaintiff. The car was inclusive. At the end, by an outrageous act with defendants evil intentional to create undue hardships and emotional harms for plaintiff, that act was not just only affected plaintiff, but the emotional harms also have affected the mother of plaintiff as well. Instead of showing appreciative to her son for the time and efforts that he put in help them, these people, defendants, repaid by their evil deed to punishing her son, plaintiff. Without give reasonable time notice, defendants repossessed their loaned vehicle provided for her son to drive and accused her son, plaintiff, as thief, while the defendants knowingly that plaintiff could barely walk because the work-related injury that occurred at defendant's property. Mother of plaintiff shed tears when she saw the predicament plaintiff are now in. Plaintiff firmly stated that the defendants are not just unkind, but also selfishly filled with greed, and loaded with evil intentions proven by deeds they have done not just toward plaintiff, but to others as well. The lowest wage plus there always were many projects and assigned works that had no advanced funding until they were reimbursed, if ever, had made plaintiff constantly broke and never had enough money. Thus, plaintiff had no saving and no backing capital to sustain. Therefore, foods and supplies, from mother of plaintiff with the money from her own purse twice a week she helps her son, plaintiff, to survive through the pandemic. Back to the matter that presented to plaintiff from person sang, it compelled to plaintiff that this matter could be another tactic played out by defendant Elizabeth, but for what was the purpose in this emergency late-night call? Not feeling well, plaintiff got up out of bed, got ready and plaintiff could not put on the shoes the toe will be hurt if do so. Thus, plaintiff reluctantly went out the door with a pair of slippers on his footwear. After taking care at the center, person sang said to plaintiff that defendant Elizabeth also asked him to tell plaintiff that the door where the homeless were, that door is damaged and could plaintiff help to fix it tomorrow. Exhibit 49. 17A and 49. 17B. Unfortunate for plaintiff, while got inside the car and tried to get out of the parking lot, plaintiff injured toe hit the brake paddle and that was hurt badly. Exhibit 49.19. The injured toe hit the brake paddle caused pains that plaintiff had tears at the eyes. Plaintiff wondered do defendants know what the price plaintiff had to pay for to help defendants. This matter got plaintiff down and out sick in bed form June 18, 20 till July 2, 20. On July 2, 2020, after got better plaintiff found an email from defendant Elizabeth, sent, dated June 17, 20 with defendant Elizabeth thanks to plaintiff helped with person sang that night, see, Exhibit V, P 49-3. On July 2, 2020 plaintiff also found an email, sent, dated June 17, 20 finally, for the first time, defendant Elizabeth acknowledged plaintiff's resignation, Exhibit V, P 49-4. Plus, dated on June 29, 20 defendant Elizabeth sent plaintiff a ROP accused plaintiff as thief, and used the law enforcement's threatening that defendants will take actions on the false claims stated in the ROP Exhibit V, P 49-23. Early in the morning of July 1, 20, defendant Elizabeth recklessly and taken the law into her own hand and violated an enacted law AB No.2501. The self-helped repossession of a leased vehicle which plaintiff as the proper holder of that vehicle without any fair warning defendants had breached an oral contract with plaintiff. Defendant Elizabeth carried out as illegal self-help repossessed a vehicle which was loaned to plaintiff prior to a legitimacy of a certified mail notice of defendant's intention got to plaintiff and given no concern for plaintiff's personal effects. Important items such were plaintiff's cell phone and medications were left in the vehicle. Exhibit 49. 25. On July 2nd of 2020, plaintiff made a call from a neighbor's phone and left a message regarding personal effects and medications belonged to plaintiff were in the vehicle and warned defendants that all of plaintiff's properties in the car as well as stored in the 2 units 205 and 208 at Saigon Center that accountable to the defendants should anything happen to them goes the same towards intellectual properties copyrights plus plaintiff designed inventions. By defendant Elizabeth was unwilling to release personal properties to plaintiff. This matter is a criminal offense with intended to steal the properties belonged to plaintiff. It is an act of larceny stated in the CA Penal Code Chapter 5, 484 to 502.9. After the work-related injury, plaintiff communications with defendants had gotten dismayed. By this time, it seemed as there only one-way communication and there was none or lack of receiving from defendant's end. Mainly affected by following 3 factors, the way defendants ignored of the work-related injury and other inquiries, 2, the injury had gotten worse caused plaintiff to be immobilized, and 3, plaintiff simply just excessively tiresome with the pretentiousness and misled from defendants. After plaintiff had injured at work, defendants were failure to act on it, indicated that defendants had no worker compensation insurance and had not responded on the matter to plaintiff regarding a written report on the incident which plaintiff stated in an FYI memo sent to defendant Elizabeth on May 29 of 2020. Exhibit 3. Part P.28.1 located pages 89 to 93 of the preliminary pleading. Defendants also further failure to act on and did not respond to the notice of resignation that plaintiff sent out the second time on June 11, 2020. On the night of June 17 of 2020. After helped person sang, former assistant, on the way home accidentally plaintiff's injured right toe hit the brake paddle while driving, plaintiff could not wear shoe and had to wear slipper, disturbed the wound, caused it to bleed out blood again, and the infection started. Thus, from 6/18/20 to 7/2/20 plaintiff could only lay quietly, and accepted things happened as the faith played out while plaintiff stayed, immobilized, sick in bed. Since it had happened before, plaintiff avoids similar event from repetition. If allowed, Defendant Elizabeth will try to have the communication back online. Defendant Elizabeth will change the directions to another urgency matter, put plaintiff busy with other responsibilities, and Defendant Elizabeth will ignore those pre-existing issues totally, and then Defendant Elizabeth will act as nothing ever occur. Plaintiff had enough of these smart tactics played out by Defendant Elizabeth. 3 years of plaintiff's life had gone into dust by worked for defendants almost like a slave under Defendant Elizabeth cleverness, always undermining the means of logics and cover up factual issues to cause conflicts between realities and falsehoods, put matters harder to reasoning any counter-argument. Nevertheless, some matter remains untold due to the scope of plaintiff's complaints related to wage theft and lower wage exploitations herewith in the pleadings of this case, which plaintiff intended to disclose them briefly at the final in the following subpart 49:28 and will report the details with the district attorney office on those criminal violations. Through the unexpected finding facts that plaintiff discovered in May and June of 2020 was the final conclusive, helped plaintiff to realize how calculative and malicious defendants really are. Plaintiff as the first-hand witness and plaintiff does bear valid testimonies that have substantial proofs on not just federal and states taxes avoidance crime of defendants purposely cheated the federal and state income taxes, insurance fraud crime, and a crime of perjury and obstruction of justice in court that defendants committed. Moreover, defendants had set things up in stages so conveniently blamed at plaintiff for the causes and pressured plaintiff to comply with defendants' orders, forced plaintiff involuntary be involved these criminal plots, suppressed plaintiff to honoring a non-disclosure agreement that was signed by plaintiff. Conclusion. How and when their action occurred, plaintiff clearly noticed the hidden evil intention and way of timing constructed in a plan that aimed to maximize the undue hardships towards plaintiff and family member during the worst time of a pandemic. Surely that would not yet be enough to satisfy defendants' standards, as it had ended. I've been witness of how defendants reacted and handled these negative matters in the past toward their opponents, had provided plaintiff an awareness that more bad things will come and will be worse to plaintiff. Now what plaintiff had afraid of might happen already had happened to plaintiff. The defendants retaliated by taking away plaintiff personal belonging items, especially plaintiff's cell phone, whereas its value is merely nothing. However, its contents storage many solid evidence against the defendants. Furthermore, the defendants locked up those two units number 205 and 208 of the building located at 10451 Bolsa Avenue, City of Westminster of the State of California, Postal Code 926A3, with all the personal properties, tools, equipment, and everything of plaintiff's livelihood were stored inside of these two units. This action take even against their verbal permission was granted toward plaintiff the rights to use the two units, 205 and 208, as workshops, and plaintiff can bring tools and belongings to work, while these units are vacated. The whole ordeal has brought many injustice issues toward plaintiff, and thus, this matter becomes as an important commitment of plaintiff to bring it to justice so that no one would ever be in the same predicament as plaintiff had been experienced again by the defendants. Feared of more harms will come to plaintiff, plaintiff warned to defendants that plaintiff will seek justice on this injustice issue and warned that plaintiff aimed to let the court and the officials at the Labor Commissioner decide on plaintiff complaints. Please review proofs in emails in the following pages 25, 26, and 27 of this paper. Defendant's tone quickly changed from evil and threatening toward plaintiff to nice and soft, with warmed express regrets toward plaintiff with explanations justified their acts. While defendants denied plaintiff the rights to reclaim personal effects and medications were left in the vehicle and other properties such as tools equipment that stored in the workshop, Units 205 and 208 10451 Bulsa Avenue, Westminster, California 92683. Of which the tools and materials plaintiff had prior plus items were purchased from August 2017 to June 2020, with proofs, with plaintiff owns money to doing various projects for defendants at the two locations and no reimbursement ever been offered. While defendants had changed all the locks and locked up these two units, at the same time constantly asked plaintiff for the keys of these units, and this matter did not make any sense. As stated previously, the past 3 years had taught plaintiff about the dangerous of defendants viciously and perhaps even illegally intentions set out for plaintiff, since now plaintiff become a thorn in their eyes, matter of speech. As someone whose defendants like to set the scores and to defendants, plaintiff deserved a lesson like they had done to many others. For instance, defendant B once said to plaintiff, as quoted, "That'll teach them a lesson, they should know who they are messing with." A comment said plumly to plaintiff after an event that defendant B exercised her landlord authority by threatening eviction to a tenant if he does not comply with her demands. Defendants were succeeded with their outrageous action. The emotional harms that have made plaintiff's mother suffers. She did not share, but plaintiff known that it is there, and plaintiff deeply hurts for the foolish choice plaintiff made to help defendants and the negative consequences, now the hardships that plaintiff and mother have been endured. This whole episode changed plaintiff emotionally. Plaintiff could not feel free as before, as happy, and willingness to help anyone even before was asked. Plaintiff was living a life with socialize and volunteerism. A joyful life was filled with happiness. Unlike this moment of time, sad, depressed, hurtful, and loaded with doubts. Plaintiff do hope that the pandemic fatigue symptom does play a role in that. Plaintiff knows for certain, someday plaintiff will forget this matter and all the existing pains, both from emotional and mental, will be gone and away like the memories of unpleasant events happen through life, and plaintiff just can wait for that day. Through deceives, lies, cheats, dishonesty, and manipulatives, defendants had robbed plaintiff emotionally, and it is hurting plaintiff each time when plaintiff see also the pains and sadness that because of plaintiff have unfairly placed onto plaintiff's mother. On this date of June 5, 2021, plaintiff compiled this legal document as an amendment, so-called as Amendment 101, and wished it to be amended into the previously submitted preliminary pleading, of which was dated and signed on January 9, 2021. Due to the current health threats of the pandemics of coronavirus COVID-19, of which it has created immense challenges and difficulties to our community social norms, for everyone and everywhere. Plaintiff, in proper person, by utmost humbleness, fully respect to the health and well-being of everyone, above all else throughout this pandemic time. Henceforth, plaintiff respectfully submitted this document of Amendment 101, with no intention to expedite the case during the pandemic. However, please accept this paper as a legal document of which plaintiff, under OATH, shall bear the legal responsibility for its stated contents. Plaintiff hereby certify to the best of my knowledge, information, and belief that this legal document, 1, is not being presented for an improper purpose such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. 2, is supported by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law. And 3, the factual contentions have evidentiary support or, if specifically so identified, will likely have evidentiary support after. A reasonable opportunity for further investigation or discovery. Dated June 5, 2021. Quang Viet Tran, plaintiffs. Improper person. 9722 Imperial Avenue. Garden Grove, California 94844. 71488900048 cutran98@outlook.com. Plaintiffs. Praise for equitable compensation for stolen personal properties. Defendants had ignored plaintiffs' rights to own properties and even attempted to make false claim on plaintiffs' personal belongings plus intellectual works of plaintiff as defendants owns properties and rights. Exhibits V. P. 49-4 and V. P. 49-23. As landlords, defendants were always poised with their expressed rights when claim other tenants' properties as abandonment as the same way defendants claimed and had unfairly done it towards plaintiff. It was hard to believe that someone took others' belongings and never had any shame of it. Especially those items are matters of one's livelihood. Furthermore, important medications essentially affect one's health. Yet the defendant's action not just ignored plaintiff legal rights to personal properties, but defendants further implicated how much defendants respect for the health and well-being of plaintiff as an employer to an employee by deliberately kept other essential items such as personal cell phone, medical support back brace, and medications that were left in the loaned vehicle. Even when plaintiff proposed an inquiry to compromise see if we could meet it midway. But return plaintiff belongings was not an item registered in defendant's agenda. Exhibit 28/33/101. I denied plaintiff the rights to reclaim personal properties and intended to keep those personal items from plaintiff permanently. Plaintiff considered it is an act of stealing, it is theft, with an intent. Plaintiff hereby prays for the compensation costs for those personal effects have been stolen by the defendants. Without knowing the current value, however, the total value plaintiff able to prove is $15,000, $15,000. Plaintiff initial report, wage theft claim. Exhibit 49 ends. Email defendant Elizabeth sent to Foreman Sanchez and forward to plaintiff regarding an inquiry for Foreman Sanchez to get keys of the center from plaintiff. Plaintiff complied to the requested in this email and gave keys Jose Sanchez. Note, keys some were in the loaned vehicle and the rest of them were in both units 205 and 208 that plaintiff used for his workshops. Besides, the vast of equipment, tools, medical aids, and various belongings that belonged solely to plaintiffs. They're valued at $15,000. Exhibit 49. 6. Plaintiff area of injured right toe. The night plaintiff left home went to do the work for defendants with person sang. Image captured by plaintiff's mobile. After the bleeding stop, person sang helped wrap this body part with paper restaurant napkin. We were without first aid kit and the time was past midnight 0:38 a.m. on June 18, 2020 when we both got home. From plaintiff's records, defendant owns person sang at least 4 hours, counted waiting time. Moreover, this was not the first time defendant Elizabeth skipped paying to person sang. Exhibit 49.19. At first, plaintiff had no idea about why defendant Elizabeth kept on asking about the keys, even though defendant Elizabeth, she does have them, units 205 and 208. Because the last time prior to COVID-19 plaintiff already made them keys for defendant Elizabeth. Plus, Foreman Sanchez, he has all the keys and he also know where the rest of the keys were stored at, in unit 205. Exhibit V, P 49-3. On the night of June 17, 2020, defendant Elizabeth monitored plaintiff and person sang activities through security cameras. Exhibit V, P 49-3, Cont. Exhibit 49. 17A. This is the usual smart tactics played out by defendant Elizabeth: disregard other people's concerned matter or their well-being while demand full attention on only defendant's agendas. Always expressed a great deal of concerns and yet immediately redirected the conversation to new assignments and or the next item on the agenda to abide. Defendants received plaintiff initial report on the work injury on the end of May. Then on June 17, 2020, with a report from Foreman Sanchez, by sent him over for the keys and to check on plaintiff, also with the report on plaintiff health condition from person Sang. Moreover, defendants been monitor plaintiff and person Sang through security cameras for the whole time on the night of June 17. With all that information, defendants had enough of details to decide what to do to plaintiff. Exhibit 49. 17b. This email final recognized plaintiff resignation. As the communications indicated to plaintiff that defendants consistently nonstop pressured plaintiff to carry out more works for defendants regardless plaintiff health's condition. All communications occurred on a same night, got plaintiff out of a sick bed while suffered in pains, came to their aids, but after a thank you note, emailed, then 40 minutes later gave plaintiff a note 24 hours notice or else. Of course, this demonstrated to plaintiff it took defendants lesser than an hour to forget that prior they were grateful to be helped. Exhibit V, P49-4, the ROP contents. While withholding 2 months' payments money plaintiff needed for the rent and taken plaintiff properties/personal effects, defendants dared to slander plaintiff as thief while defendants already had committed these crimes like property theft and wage theft. Exhibit V, P49-23. Emails plaintiff responded to defendants regarding the ROP and warned defendants on seeking for justice. quangtrancutran98@gmail.com. July 1, 2020, 10:24 p.m. Tour Plaza. This is full of shit. Do you know that I got hurt at your place and now I could not even walk, so please be nice. I did not and yet think about take you and what you have to court and the U.S. Department of Labor for been used and mistreated, so my best advice to be nice to each other. That is the main reason why I've been silent, cause I do not want a sad thing that damage anyone, but don't try me on that. Apologize for plaintiff's bad choice of words as could not hold back in that moment. quangtrancutran98@gmail.com. July 1, 2020, 10:38 p.m. Tour Plaza. One more thing I should add: if you mention about things like computers, electronics, tech tools, hard drives, flash drives, documents, site plans, tools and equipment and any other materials belonging to employer, I will bring all receipts, proofs, those things that I bought and paid for out of my own money and never had any offer to reimburse, and other plan and drawing are my copyright and intellectual. I do own them, they are not yours, so when making claim, make sure you know that those things are really your or you are trying to rob me. Don't push me to the edge. In comparison with the previous contents in the 24 hours and the R.O.P, the tone changed. Plaintiff's correspondence. From defendant Elizabeth. Email from plaintiff to defendant Elizabeth. The highlighted and underlined by plaintiff, purposely only for this paper and not display in the actual email. The part that plaintiff mentioned to defendant Elizabeth in the email above was related to the executive order given by California governor, of which defendant Elizabeth was the one provided to plaintiff as study material. Thus, defendant Elizabeth was aware of its contents. In fact, defendant Elizabeth even lectured to plaintiff on the subject and opinions between the California Executive Order and the Federal Care Act. However, in the corresponded email that posted next page in this paper, page 28, as to avoid admission of the wrongdoing, defendant Elizabeth deliberately steered the subject to another topic such as essential workforce. Exhibit 28/33/101. Plaintiff final attempt in hoping that defendants release plaintiff belongings in exchange for the keys, even plaintiff no longer possess them. Exhibit 49. 25. The end.